There are questions raised about judicial independence again. It's a burning topic.
Yeah.
With all the metaphors that we can think of about burning.
Everybody's talking about
Everybody's talking about it.
There is topic for the month, topic for the week,
and
this
topic
is the topic
ever.
of the day.
Topic ever.
And this is the
evergreen topic, and now
correct.
it's like spoken by everybody.
Yes.
Led to questions as to whether the judiciary needs to be in line with the thought of the the ruling elite of the country. Okay, and that time it was a different set of considerations.
A process which has totally excluded the union government from selecting the candidate. Shall we say that?
See, in theory, yes. Since this High Court Collegium has become irrelevant, okay, except for the first screening, they have become irrelevant because they also don't know what the Supreme Court Collegium is doing. If they know, we don't know.
For me, when I heard this word called Collegium system, the only thing that comes to my name, the thought which comes to my mind is about selecting a pope. That is where the Collegium is used in Ropen at the Catholic Church. When a pope is to be selected, that is when there is a collegium which sits in a closed door meeting and then chooses.
It's unfair to the collegium, it's unfair to the pool of people available to become judges.
Unfair to the society also.
That goes without. I think you have trumped the what is unfair. Do we need a change from the current system of judges appointing judges? 100% we need a change.
You think so?
100%. Confusing appointment with inefficiencies of the judicial system is another mistake we make. Is the collegium system throwing up more diversity of judges in the High Court and Supreme Court than the earlier system? And if we look at take 2 or 3 judges, for example.
Something similar to NJAC but different from NJAC. The time has now come for a change.
You said active practice. Now, what do we mean by active practice?
Yeah, that's where we have to define probably. Active practice is something where he is not enrolled and he has sufficient wakalat.
So, greetings from VAKEELA VAAHINI, a bilingual magazine for advocates by advocates. I take this opportunity to appreciate all our subscribers and listeners who give very good feedback. We thank you for that. For all the first-time clickers who have clicked for this podcast, I will take a moment and purposefully and intentionally welcome you for this to this whole VAKEELA VAAHINI podcast family. I'm so thrilled that you are here to listen to this conversation, which is on a very relevant and most spoken as of this week and last. So I'll take this opportunity to introduce our speaker, one of the persons whom I'm going to converse, Shri Harish Narsappa. He's a very sought after designated senior advocate, predominantly practices in Karnataka High Court and also in Supreme Court and various other tribunals. He has worked at Herbert Smith in England and for almost 4 to 5 years and gained a lot of experience. He's a co-founder of Samvad, which is a legal firm, does both national and international work. He's the author of a book called Rule of Law, Quest for Reason. It is a book that deals with what is promised in our legal fraternity and what is actually you get, which is a very interesting read. He's a founder of Daksh, which is a non-profit organization which deals mainly or works in the field of accountability and more so in the field of judicial accountability. And I welcome him today. Thank you for coming. Let me now introduce you to our next guest, Shri S.N. Prashant Chandra, a very popular local advocate with 38 years of practice. And if I can say personally something about him, I would be very happy to say that he's like a walking encyclopedia in our courts. You ask him any situation, a legal situation, he will very smilingly answer. Be it litigation, adjudication, mediation, lok adalat, everything. So he's a all-in-all person. He has authored a book which is called as Commercial Court Act. For that act, he's written a very nice book. He's going to update it very soon. In Karnataka, if I'm not mistaken, you're the first person to write a book on Commercial Courts Act, which is a very path-breaking legislation, if I can say. And recently, he has authored a bill for the governance of Greater Bangalore Authority. And I'm sure most of you would have seen that our governor had took a look at it last week or something. Prashant.
Namaste.
Chandra. So I have two great jurists, and that means we should speak about something very important and that which is relevant today. So what would you think that would be?
Well, see, I always say that in our country there's never a dearth of topics. Right?
Okay,
There's
that's
always
nice.
some development or another happening, because we're, in a way, I mean, if you look at it, the positive side, we're such a vibrant society, there's something happening. But since we're gathered in a week where there are questions raised about judicial independence again, it's a burning topic.
Yeah.
With all the metaphors that we can think of about burning.
Everybody's talking about it.
Everybody's talking about it. So both in terms of appointment processes for the higher judiciary and accountability, it's always a relevant topic, but I think, in this month it's, and over the last 3 months, several other instances have also arisen, I think, so that's an important topic that we could talk about.
Prashant,
Subject to what
do you
Prashant
agree?
thinks.
I fully agree with him. There is topic for the month, topic for the week, and this is the
topic
topic
ever,
of the day.
topic ever.
And this is a
Evergreen
green
topic, and now
correct.
it's like spoken by everybody.
Yes.
I know when I was thinking whether we should do again a topic like this, because so much is being spoken about. But I feel we are a country of 130 billion people. And everybody should know what is this judiciary, how it functions, how the appointment happens, what are the difficulties there. And when intellectual people like us sit, then I think that conversation should be fruitful.
And you rightly said, it concerns all.
It concerns everyone. So the whole of the country are stakeholders in this, and any number of conversations, it's still worth it
Correct.
is what we can console ourselves for taking this topic today. Harish, can I request you to just, so that for our advocates and non-advocates who are generally busy in their offices, not so much worried about to become a judge or not to become a judge, just give a small preface of what was happening from the time we got independence up to the Collegium system came, and how did the Collegium system take over?
See, if you go by the text of the Constitution, it's very clear that judges are appointed by the President of India.
Correct.
But because of the interpretation that the Supreme Court has given to the decision-making powers of the President, it essentially means the decisions are made by the Cabinet. And the President acts on the advice of the Cabinet. So essentially, if you go by the text of the, let's be clear about that. If you go by the hard text of the Constitution, the President appoints. If you go by the interpretation given to the responsibilities and powers of the President, he or she, whoever it is, acts on the aid and advice and recommendation of the Cabinet. So, which essentially means the executive appoints has the power to appoint
as per Constitution.
Well, I mean, that's why I said if you go by the strictly the President, and there are votaries who say the President should decide independently.
Okay.
But the powers of the President are limited by judicial interpretation, and except in a few areas, the President means the Union Cabinet, Governor means the State Cabinet. So let's go with that position for the moment. And until the mid-80s, that was the position, right? And while there were murmurs about certain judges, even from day one, from 1950, about whether, for example, because when we started in 1950, most of the judges were people who had trained and worked under the British system, under the British colonial system.
That's right.
So the first amendment of the Constitution itself with regard to land reforms was brought about because the Supreme Court struck down certain land reform legislation.
That Shankari Prasad.
Yes. So that itself, led to questions as to whether the judiciary needs to be in line with the thought of the ruling elite of the country. Okay, and that time it was a different set of considerations. We're a newly independent country. should we have a set of judges who are thinking only in terms of hard law and not in terms of what's happening in the country, right? And what changes were required. So there's, in terms of having a tension between the judiciary and who appoints them, has been there from day one.
Okay.
And the background of the judges.
Even in the
from day
earlier
one, from day
also,
one, as
okay.
to who should be the. But it was not. But by and large, so the executive respected the independence of the judiciary. And while they may have been unhappy with judgments coming out of the Supreme Court and the High Courts, there was no overt attempt to influence the balance or tilt the balance in one favor or the other.
Okay.
I think the overt attempt started with the, when the supersession of the judges happened first in 1973 and then in 1977. When Chief Justice's first, somebody from our state, Justice K.S. Hegde was superseded, overlooked to become Chief Justice, and then later on, after the ADM Jabalpur case, then Justice Khanna was superseded, and then there was a law minister during Indira Gandhi's time who said, we need committed judges, right? And that's when the overt talk about executive having certain kind of judges who suited the ruling powers of the day and appointing them came up. And the response by the judiciary was, what we have today. Although it didn't happen overnight. In fact, in the first, what we call today the first judge's case, the Supreme Court said, no, the appointment powers has to be with the executive. But they said, the Chief Justice of India should be consulted, all of that. It was only later on in the succession of the second judge's case, third judge's case, and late, in the NJAC case, that is the most recent case. Through the succession of cases, the power to appoint was essentially appropriated by the judiciary, where the Supreme Court judiciary, and there also there is a twist. So the Collegium, in terms of appointment of the High Court judges, the Chief Justice and the two senior most judges
of that particular state,
of the Supreme Court, of the Supreme Court, of the Supreme Court. Okay. Chief Justice of India and the two senior judges of the Supreme Court are the Collegium. For appointing judges to the Supreme Court, the Chief Justice of India plus 4 more.
Okay.
Now earlier, and this is where I feel quite strongly about this, and this is something I feel we neglect sometimes. Earlier appointment to the High Court, the High Court Chief Justice and the Chief Minister of the state and other judges also used to have a significant say. Even now they do, in the sense that the first round of whatever collection of names is done by the High Court Chief Justice and the two senior most judges, what is called the High Court Collegium. But really we don't know what happens at that stage. No one knows. That's a completely opaque and non-transparent process. What is now visible to people outside this Collegium system, outside the judiciary, is when the Supreme Court Collegium publishes recommendations, and they started publishing this also recently, when they send judges to the union government. So in a way, there has been in my view, the way it currently functions, because you asked me how it currently functions. The power, if you look at it, is actually only with the Supreme Court Collegium. They are the ones who recommend to the union government to appoint. The High Court Collegium does not have the power to recommend directly to the central government.
Yeah.
They are sending names. Now, we don't know, nobody knows how many names the High Court Collegiums are sending.
How much is
How
getting
many
screened?
of them are being
screened or taken or rejected?
Rejected, not considered? We don't know. We don't know. So what we know, what is publicly known, is that the Supreme Court Collegium, consisting of the Chief Justice of India and two senior most judges as far as the High Court is concerned, and Chief Justice of India plus 4 senior judges as far as the Supreme Court is concerned, they send certain names to the central government, and then the central government publishes that. The central government is supposed to not have any discretion with that, because there's a memorandum of procedure that's been adopted. But if you take the last 8 to 9 years, the central government is actually, doing what it wants. The Supreme Court, in fact, there are quite a lot of articles that the Supreme Court Collegium has essentially become a search committee, and the central government is, doing what it wants. So currently, that is a process. So earlier, so essentially we are familiar with two processes. Until about the late 80s and early 90s, we had one procedure where the appointment was done by the union government, and after that we have the
Total a process which is totally excluded the union government from selecting the candidate. Shall we say that?
See, in theory, yes, but what I understand is there's a lot of discussion that does go on, and even with the chief minister of the state, with the central government through the Department of Justice, names are before the formal recommendation by the Collegium is sent
from
the Supreme Court Collegium. I am only talking about it.
Yes.
I think in a lot of senses, this High Court Collegium has become irrelevant. Okay, except for the first screening, they have become irrelevant because they also don't know what the Supreme Court Collegium is doing. If they know, we don't know. So let us say we are only speaking about from what we know. Okay?
Yes.
And we may be wrong. They may be very well informed. They may be fully informed, but we don't know about that process. So we can't comment on that. So what is visible to us outsiders is that the Supreme Court Collegium sends these names. But before the formal recommendation happens, I understand there's a lot of informal discussions also. So it's not as if there is no discussion. For example, intelligence inputs are given, and if there's certain candidates are found unsuitable at that level, the recommendation is not made, is what I understand. So there is informal communication, but it is not, the power is vested currently with the Supreme Court Collegium. Power of recommending.
Correct.
Power of issuing the notification is with the central government. Central government cannot recommend someone on its own. So to that extent, you're right. They can't choose anybody.
And they can't send a list to the Chief Justice
send a new list to the
of
Chief
India
Justice.
to say we would like or are recommending these as per the present system.
As per the present system.
So I'll before I just go to Prashant, what I will just tell you what my thoughts were. For me, when I heard this word called Collegium system, the only thing that comes to my name, the thought which comes to my mind is about selecting a pope. That is where the Collegium is used in Ropen at the Catholic Church. When a pope is to be selected, that is when there is a Collegium which sits in a closed door meeting and then chooses. So I always felt if that is kind of process that is adopted, then what appointments comes out or should be akin to persons who are going to be doing great justice in the courts. That's how I feel, and so therefore I feel there's a lot of sanctity in that process. That's my personal opinion. But somehow over the years, I kind of stand corrected on that. But still, I would like to say that by and large, that is a system that is the best among the worst is what I feel. But however, I would like to, before we go on to the next issue, Prashant, would you like to add anything on the existing system?
Anu, we are discussing about the appointments to the High Court and the appointments to the Supreme Court.
Correct.
What we will understand from Mr. Harish now is the appointment was earlier by consultation, then it turned out to be by concurrence, then it became Collegium, then it led to the important case of NJAC, National Judicial Appointments Commission, where we had the Supreme Court striking down. And there, at the end, while striking down, they said that this Collegium system is also not free from its own opposition drawbacks. However, they say that it needs to be changed.
Because we are where we are, and I don't think it's going to be easy to modify the system so quickly. The NJAC bill itself took about 20 years, about 20 years before there could be some consensus. And then, of course, it was struck down, but it took 20 years to arrive at some consensus, right? But currently, so there's a longer term change in terms of, do we need a change from the current system of judges appointing judges? 100% we need a change.
You think so?
100%.
So
we can't have a self-perpetuating system.
Let's take 2-3 minutes to discuss why you need a change.
One more point I'll add, and then we can. The second point, which is a more immediate need, is the complete lack of transparency for everybody involved, including candidates who are being considered. They also don't know. I mean, many of people we know who get appointed to judges, they're also living under constant
don't know what happened.
uncertainty.
If you ask any of us, we don't know what really happened.
Constant uncertainty.
Yes.
In fact, Anu, on the Friday they were with us. On Monday they were already appointed. This is how it has
So
been.
there is a lot of lack of transparency. This current lack of transparency should not continue for more than even a minute. Okay, we need to be transparent. And I just want to add one more point. See, if it was the judiciary considering this kind of appointment by any other arm of government, they would have struck it down
in a minute.
Correct.
Right.
Yeah. Okay.
So to think that we are somehow unique is correct because you have a unique role under the Constitution. But that doesn't give you the power to appropriate aspects of bad governance that the judiciary constantly finds fault with the other arms of government.
So we are kind of on the same page that we need a change. But I need to understand why we need a change. One, I agree with what Mr. Harish is saying, that if it is not transparent, for a good working democracy, theoretically it needs transparency. No doubt on that. But if the system is bringing out candidates and which is functioning well, or if it has functioned well from past these many years, why do we then need a change? Or do you say that it has not functioned well? So
no, it is not that we are saying that there is a change required. It is the Supreme Court itself is saying that.
Oh, okay.
And it is already 1 decade after that. See, the India situation is different from any other country in the world. We are unique.
So
we
then
have
what
our
you're
own
saying
way
is we
of,
don't need to discuss whether there's a required change because
Yes.
Supreme Court itself has acknowledged there's a change required.
And you can even take the example of the last 1 week because you said the topic of the week. It has been happening. Discussion is happening everywhere.
Okay, there are 2 points I want to make here. Prashant, I'm sorry I interrupted Prashant, but see, whether a new system will give us
Anything better?
judges,
Yeah.
I don't know.
You don't, yeah.
Right?
Nobody knows.
And in fact, this is a thought that's been on my mind that we should, for example, study the quality of judgments before the Collegium and after the Collegium.
Correct.
Right? I mean, we haven't done that, and it's required to be done. But I don't know whether we will throw up better quality judges. Okay, because the pool from which you select from is the same, remains the same. It's not as if the pool changes just because the appointing person changes. Maybe their visibility will change, but that's a separate point, right? But the very process of appointment needs to inspire confidence. And when we started this program, you said, it's for the lay citizens as well.
Correct.
So how does it look that you have one arm of government that essentially is self-perpetuating in terms of appointment? And that is a problem. If you look at it purely from checks and balances, purely from we're a democratic country, democratic republic, where the ultimate power vests in the people, then you need to have a transparent system.
Transparent system.
Okay, that's the first
That is the
point.
basic requirement.
Yes. The second point is, and this is something that I often point out, that, listen, confusing appointment with inefficiencies of the judicial system is another mistake we make.
Okay.
I think
they're two separate things.
Inefficiencies of the judicial system, because people say, you have 4.5 crores, 6.5 crores, every 6 months the numbers change. You have 6.5 crores cases pending. What are you guys doing? It's all because your appointment is with you guys. I don't think so. I think there are two separate points. Irrespective of who appoints judges to the High Court and Supreme Court, there needs to be a larger judicial reform process. That's a separate issue, and that there needs to be one. Appointment is a small aspect of the overall judicial process system. But because we are dealing with the High Court and the Supreme Court, I mean, nobody is questioning the district judge's appointment. There are people suggesting reforms there also, but
by and large,
they're saying, okay, there is an exam.
Picking up the best.
There is an exam,
a process which picks the best.
Correct. To the High Court and Supreme Court, the appointment process is skewed, right? And everybody recognizes, because as lawyers, if you read the text of the Constitution, there's no word collegium mentioned anywhere. It's interpretation, all of that. So I think that's the, sort of morphed system that we're living with. And that's why this question keeps arising again and again and again. It doesn't link directly to quality of judges. What it may link, and I have to say this, and so, I would like to hear what Prashant and you think about this. It does lead to the question, is the collegium system throwing up more diversity of judges in the High Court and Supreme Court than the earlier system? And if we look at take 2 or 3 judges, for example, I don't think the collegium system would have thrown up a Justice Krishna Iyer. Because the way the collegium system operates in terms of its framework, it would not have thought to go beyond the obvious and select somebody like Justice Krishna Iyer, or even somebody like Justice Vivian Bose, or Justice K.K. Matthew. I think that is a drawback of the collegium system because of the inherent limitations it has in terms of the decision.
By picking up their familiar people.
No, not just familiar people. Look at it. I mean, who are the people who constitute the collegium, right? It's the Chief Justice of India and 4 senior most judges or 2 senior most judges, depending on who it is. They have a full-time job.
Yeah.
And they are sitting in court from 10:30 to 4:30.
Correct.
Then they write judgments. Then they write, and then they have to monitor, basically about 1,000 judges.
The judicial work itself, in my view, is beyond a human's capacity. The kind of work that our judiciary is
overwhelming. It is overwhelming.
It's amazing.
So the ability to look at a wider pool, the nature of the collegium prevents
itself.
Whereas we can just take the example of Krishna Iyer. Krishna Iyer was a High Court judge.
He was a minister.
Resigned. He was a minister. He was a avowed communist. He resigned, then he was brought to the Law Commission and from there appointed to the Supreme Court. I don't think it would have happened today with the collegium because they are limited because of who they are.
You're saying that vision is limited, is that what you're
Not
trying?
Vision, because of the office they hold.
They don't have that much of access.
They don't have,
access to the great intellectual arena that's in front of them. They don't have that much access.
By nature, they're not exposed.
But the whole collegium system, if I were to we'll take a couple of moments to discuss, was about choosing the ones that are coming every day in practice in front of you. So you are seeing their work and therefore you kind of believe that they will become good judges. And I think it was with that view that this collegium system.
Broadly agree with you, but I think there's one more problem there. One, I think they're essentially selecting candidates, what I call the familiarity problem.
Yeah.
So you are selecting people from the pool that is familiar to you, okay, which is not the way to go about when you're appointing people for constitutional
dispensation of justice, you need a variety.
For constitutional positions, that's one. Second, we don't know enough even to comment about this. We don't know how they're choosing.
Yeah.
So it's okay for us to say, but how have we heard about this? Again from whispers, right? Where is it published? For example, for the High Court, how do we know when the High Court Collegium is sending names for appointment to the High Court? How do we know who they are choosing? What is the process they are following?
From what we have heard, they say that they will see who are all practicing before the courts.
Appearing before them
or their colleagues, and then they say who is good. I am saying there itself is the first lacuna, that you have made the vision only this much of people who are appearing. There may be many gems who are sitting elsewhere, did not have an opportunity. Maybe their practice of law may not be the ones that brings them to to your courts.
I agree.
So then you're really lost
there's no. See, we need diversity of representation.
So when we say representative diversity, now we only understand it as give representation to women. That's a totally different chapter that we'll discuss a little bit about that. Then give diversity to the minorities, then to the other backwards, and so that is what we call.
I'm talking about something different.
Yes,
I'm
that is
talking
what I
about
want
diversity
you to
of experience.
Correct.
Diversity
that we don't have.
Diversity of worldviews, right? Sometimes it may come from giving representation to women, minorities, all of that. Sometimes it doesn't come, because I'll tell you what, you could find, this is something that has bothered me quite a lot. I mean, you could find a woman, you could find a minority candidate, you could find, people belonging to different castes, and all of them could have had the same professional experience. and then you appoint all 4 of them, you're appointing 4 judges who have the same professional experience. That is not ideal for dispensation of justice.
I agree. In Karnataka, this is happening. Is it happens in all courts? In all high courts?
Pretty much the same. I think, 2 high courts that seem to have broken the mold a little bit is Delhi and to some extent Mumbai, but Delhi, I think, is probably the only example where they have managed to bring in people from, diverse backgrounds. When I say diverse backgrounds, diverse work experiences.
Diverse in merits only.
Diverse work experiences. And diverse work experience is important for dispensation of justice because we got all kinds of cases. We need, a person, for example, to have a, good social view of what society looks like because, justice is not only about the law.
Domain experts?
Domain experts plus just an understanding of society, like empathy, right? Without empathy, how can you be a good judge?
What you're saying is emotional quotient of judges.
Emotional quotient of
that
judges.
Also needs to be seen along with the experience in the field of law.
Correct. See, because you can be because you're not deciding, and it may be true of the Supreme Court, I agree with this, although they exercise now 142, which is so wide. It may be true of the Supreme Court because they're supposed to decide only questions of law. Okay, they're being an excellent lawyer and an excellent jurist should be the primary consideration. But high courts deal with a lot more variety of cases and they need to have different backgrounds, right? Recently, I forget the name of the judge in Madras High Court, he said when a case concerning, gay people came up before him, he said he didn't understand this.
Okay.
He couldn't relate to the issue. So he said he posted the case, about 4 or 5 weeks later, so he could read up and understand what this is. Because he said, in my mind, I can't comprehend this, right? But at least he showed that he was open to understanding what the petitioners or the parties before him were going through.
Right? And put it to the right channel.
Put it, right? So, and I think that we don't have. And to be fair to the judges, where do they have the time? They're overwhelmed by the amount of work in the system, right?
Yes.
So we need to see whether we can get the best possible lot. And there's always going to be a debate about whether X was going to be better than Y. We will never be able to avoid this debate, right? And if you look at history, that debate exists every time somebody comes to power in any
institution.
So I don't think we should worry too much about that. That's why I said my primary concern is the process that you follow. Is that process good enough, transparent enough? Because transparency is now key. And is it giving enough leeway to consider all the potential candidates? And I'll take one more minute. See, this is not, we are in 2025. It is not 1995 or even 1960. When the pool of lawyers that you are considering to become judges was extremely narrow and limited. Today we have, if you look at just Bangalore alone, I'm told Bangalore and VAKEELA VAAHINI may have better numbers. Bangalore alone has, I believe, about 90 law colleges.
And we have, last month we had, 5,000 advocates enrolled in one day. In one Friday.
So when we are getting so many people, it is not as if the pool is small. The pool is very, very wide.
What you're saying is unfair for a collegium to expect to have a vision to look out so much among the...
It's unfair to the collegium. It's unfair to the pool of people available to become judges.
Unfair to the society also.
That goes without. I even think you have trumped what is unfair. I agree with it.
So yeah, I think we brought about valid points as to not so much finding fault with the individual judges or anything. We are talking about how there is a requirement of a systemic change. Of course, you have made the law of precedent as your point to say Supreme Court itself has recognized there is.
In 2015, the Hon'ble Supreme Court struck down this NJAC, what we call it as a NJAC judgment. Thereafter, they reintroduced this concept of collegium for appointment by way of memorandum of procedure. The Supreme Court invited suggestions from the bar members, general public, insofar as improvement of this collegium system. On the other side, there is an opinion, a large opinion, that NJAC is required to be reintroduced. As you recall, two eminent persons in the selection process by way of NJAC was the major reason for the NJAC being struck down. Now, we are in a situation where we are looking for a better and transparent collegium system, and on the other side, something similar to NJAC but different from NJAC. The time has now come for a change. Therefore, the above suggestions to make the system work better, which is transparent, calendared, systematic, and broad-based. This would identify talent all over the country and restore and enhance the credibility in judiciary. JAI, Judicial Appointment Authority of India. This is a body which is similar to a body which functions in the Ministry of Justice, central government. I would call this as JAI in short. JAI appoints judges to the state high courts all over India. It notifies the vacancies of state high courts. Notification will be on 1st February every year. Notifying the vacancy arises as on 1st February next year. Vacancy is to be filled up from bar and district judiciary in the ratio of 2:1 respectively. The entry age for appointment is 55 years. The retirement age is 70 years. Appointment criteria: completion of minimum of 10 years as district judge and completion of age of 54 years, whichever is later, as on the date of notification. This is for the district judge cadre. Insofar as the bar members, completion of 25 years of active practice as an advocate in district court, high court, and completion of age of 54 years, whichever is later, as on the date of notification. Then we have the different dates for submission of records, scrutiny of records, how it has to be done for the district judges and for the bar members, which are self-explanatory in the slides. Now coming to the selection committee members. Chief Justice of India is a member of the committee. He is the chief of the committee. Number 2, next senior most judge of the Supreme Court. Next, a judge of the Supreme Court who was part of the state high court judiciary for which state the vacancy is being filled up. 4th one, the Chief Justice of the state, that is to say the state from where the selection process is on. 5th, a judge of the high court who has been part of the state high court judiciary continuously for a period of 8 years as on the date of notification. Next, Union Law Minister. The 7th one is Chief Secretary of the state government. If any one of the honorable judges of the selection committee is or retiring between the period from 1st June to end September of that year, the next senior judge shall also be part of the committee. If the Chief Secretary of the state is retiring between the period from 1st June to end September of that year, senior most IAS officer of the state cadre will also be part of the committee. If there is an election to the Parliament of India between the period from May to September, the selection committee shall meet only after 4 months from the date of notification of the election. So if you have seen my calendar, the selection will happen of the High Court judges between 15th June to 31st August every year, at which time the selection committee will meet as often as it is required and will select the persons to the High Court as judges of the High Court. Now we'll go to the appointment of the judges to the Supreme Court. The first three things are common. JAI appoints judges to the Supreme Court of India. It notifies the vacancies in Supreme Court. The notification is done 1st July every year. Please note, for the purpose of High Court, it is 1st February every year, whereas this is 1st July every year. Notifying the vacancy arising in the next calendar year of the Supreme Court. Vacancy to be filled up, Judiciary and Bar at the ratio of 9:1 respectively. For appointment, the entry age is 65 years, the retirement age is 70 years. You may recall, the retirement age for High Court judges as also the Supreme Court is 70 years, equal. Appointment criteria. Completion of minimum of 5 years as judge of the High Court or age of 64 years and 6 months, whichever is later, as on the date of the notification. Appointment criteria for bar members. Completion of 35 years of active practicing as advocates in any High Court, Supreme Court, and age of 64 years and 6 months, whichever is later, as on the date of the notification. Then have the rest of the calendar of events. Very importantly in that, the selection would take place between 1st November to 15th November, where the selection committee will meet as often as required and it will appoint the judges. The notification of the selection will be made by 30th November of the same year. Now coming to the selection committee members. Chief Justice of India, first senior most judge of the SC, second senior most judge of the SC, Union Law Minister, Union Home Minister. If any of the Honorable judges are retiring, in between that period, the next senior judge shall be part of the committee. Now coming to what applies to both appointments, all submissions shall be in electronic form. Candidate interaction shall be by electronic media. Selection committee proceedings shall be in electronic medium and recorded. Candidates are not entitled to any appointment post-retirement. The committee may defer the appointment or reject assigning reasons. Rejected candidate is eligible for seeking appointment only one more time. Selection is by majority of vote. Each committee member will have one vote each. When there is next senior judge or IAS officer as a part of the committee, the retiring committee member and the senior judge, IAS officer, shall together have only one vote. The names of the candidates shall be published in the website of the authority by given date, as mentioned therein. General public, desirous of giving any information about the candidate, shall submit with all relevant records to the authority electronically before a date which is given there as 31st May. Such records are very confidential. The candidate may also withdraw his nomination at any time. For Supreme Court, the names of the candidates shall be published in the website of the authority by 15 September every time. General public, desirous of giving any information about the candidate, shall submit with all relevant records to the authority electronically. The candidate also may withdraw his nomination at any time. Now, Anu, you may ask as to what is the difference between National Judicial Appointment Commission and this new commission which is proposed, namely JAI. There are differences. Firstly, it is setting up a national calendar for appointment. Like we have the calendar of events by the Election Commission, which is very well known to all the citizens. This is also publicized, made known to everybody, and this is a national event and taking place every year. So the date is common. There is no change of the date. Now we have these income tax returns to be filed. We know that it is to be filed on a particular date, and that is rarely modified unless it requires, otherwise it is a fixed date. when we pay our advance taxes, it's also well known and there is no need to modify that. Similarly is this calendar which will have a fixed date every year. Age of entry is specified. That is to say, in the case of judges for the High Court, 55. In the case of judges to the Supreme Court, 65. Eligibility is open to the advocates practicing in the High Court of the state as also from the district bar. There is more opportunity for the advocates from the district bar to participate. Obviously, transparency is available here. Everything is recorded and is known to everyone. Opaqueness is removed. Involvement of judiciary, executive and legislature is equal and simultaneous in all the process throughout. So this is also available to us. Please appreciate in the existing method, what is being done by the Collegium is independent of what is done by the executive elsewhere. They do not meet in one common place and have a common discussion. And everything is by circulation of notes. Whereas here it is by interaction, or you would call it as consultation, as also there is discussion simultaneously happening all under one roof at one point of time, and this would actually save a lot of time of this preparation and exchange of notes. As you see from the composition of the selection committee, both to the High Court and the Supreme Court, the supremacy of judiciary is maintained. However, there is also a good mixture of executive and the legislature along with the judiciary. Age of retirement is common to both. I think that itself is a big advantage in this. All of them will simultaneously retire at the age of 70. And one important factor is merit precedes over seniority. Seniority alone is not sufficient. Even merit also has to be considered along with seniority. So that would take precedence here. Anu and Harish,
Yes.
very, very importantly, the main reason for striking down NJAC is for the inclusion of 2 eminent persons in the selection process. And if you see the general mood of the nation, people need something similar to NJAC, but with a broader and mixed selection process. I think the proposal of JAI fits to the situation. So if you ask me what are the differences in short,
Yes.
NJAC is not JAI. JAI is more elaborate, transparent and sound compared to NJAC. There is a broader selection process, a transparent and comprehensive process. Common calendar is key to the entire thing, which probably is the first takeaway from this proposal.
So let's go one step behind.
Yeah.
So you are saying that the secretariat or the commission secretariat, have you suggested what is the selection criteria? Apart from eligibility is 10 years.
Yes, 25 years of practice for an advocate.
Yes, you said active practice. Now what do we mean by active practice?
Yeah, that's where we have to define probably. Active practice is something where, he is not enrolled and he has sufficient wakalat. He or she has sufficient wakalat.
So where do we say is a sufficient wakalat?
See, I think when you're considering relative merits, now you are talking about, skills of the individuals concerned.
Yes.
And that comes to the judgment, right?
Of the
committee.
commission or committee, whoever is going to.
Right. I think so you cannot, because there's no examination, right? Where you choose whoever gets 90.
What are your thoughts on what Prashant has said?
No, so one thing I fully agree with him is that there needs to be a timetable, right? I find it astonishing that we all know when a High Court judge will retire. I mean, the day he gets appointed, his date of retirement is known. But still there are vacancies. Okay, so I find it astonishing.
Okay.
And, I think now it's better, but about 5 years ago in Karnataka, for example, we had a serious problem in terms of, the vacancies.
About 10 years ago, yes.
There was a lot of problem. If you look at some of the tribunals, for example,
there are no
NCLT, months together we didn't have appointments. So I find it astonishing that there are vacancies in the higher judiciary and the higher tribunals. we shouldn't have this situation.
So you're suggesting include the tribunals also in the...
There are problems there. I mean, ideally, yes, in the same set of procedures. I mean, I have some different opinions on this
please.
Appointments Commission.
First, let us analyze what he has to say, and then you give us
timetable.
You agree with that?
I fully agree with Prashant. I think we need a timetable, and we need a permanent secretariat. And I don't mean just these 5 people that he is proposing. We need a permanent secretariat that keeps the process running. Okay, similar to, say, the UPSC, right? Which keeps the process running, because it is we're talking about 1,000 High Court judges, right? And about 33.
The total strength, as I read last, was 1,120.
But there's always vacancy of about 30%.
There's always.
Throughout.
And then out of that, I think 849 are permanent, and the remaining are.
Yeah, I mean, which is also an artificial distinction. But let's assume 1,300 or 1,200, and say we need a permanent secretariat to ensure that there are no vacancies in this, because you're talking about the higher judiciary. So I think that I fully agree with. There has to be a timetable. It has to be a rolling process. I think there is no.
Yeah, we are on the page. Okay. Now on the next issue of how do we then say what is active practice?
See,
do we at all have an active practice, or whoever applies, be a lawyer, have practiced for 25 years?
No, I mean, practice should have actually practiced, right? You can be on the rolls of the bar, right? Whether you're practicing, I see what you're saying. It will show up in the skills that you have, right? So if you're evaluating properly, then you have 25 years experience. If you want to take a shot, take a shot. But whether you have, what have you got to show for yourself in the 25 years should come out. I think
predominantly practicing in courts is what.
No, I don't necessarily agree that it should be practicing in courts. Right?
So that's what I wanted. That's where
I have because see, the nature of legal practice has changed again from 1950 to where we are today. Right? I think there's a number of people what the litigating lawyers call chamber practice, right? Colloquially called chamber practice, right? There's a significant amount of legal practice,
yes.
Right? And many people would argue that's more lucrative. I mean, that's a separate issue altogether. But enormous number of young lawyers who are now practicing without ever, going to courts, right? So I don't think we should.
It need not be only court exposure.
It need not be only litigation experience. It can be non-litigation experience.
As an advocate, so let's say
as a lawyer. That's one thing. Then the second point, for Supreme Court at least, there is the Constitution provides for jurists, eminent jurists. Until now, there's no eminent jurist who's been appointed to the Supreme Court.
As per High Court Judge.
Apart from
the lawyers themselves being a jurist, yes.
So pure, only from academia.
Yeah.
And I think at least for the Supreme Court, I can see arguments as to why for high courts it may be a difficult exposure. But as I said, the nature of work in the Supreme Court, although there also you can now say that it's becoming more of an appellate court than a constitutional court. For a constitutional court, having a jurist makes absolute sense, right? Because there are issues of constitutional law that don't necessarily come only from litigating experience, but comes from having done deep study into issues around the Constitution through, scholarly work. In the High Court, yes, we deal with constitutional issues, but there are also other, regular appeals and regular matters, right? So that's why maybe we should start with the Supreme Court, or maybe we should try in the Supreme Court. But I think we should widen the pool is what my point is, because different, the point I made earlier, different work experiences, different life experiences need to come to the bench, because that's what going to increase the diversity of thought process in justice making. And that we don't have, that we're suffering.
We're lacking
today.
Quite a bit. I see what you're saying.
So that is important. I am not disputing the need for experience. I am disputing the need only for court experience. Okay, I think you need a wider, we need to define that. And I think Prashant said that, you need to have experience.
So can we say, by and large, you're agreeing with the model that he has given?
I have not thought too much about this JAI that Prashant mentioned. Yeah, so I'm not able to comment on that
but
now.
But
Secretariat, yes. Fixed timetable, yes. Wider pool, yes. Wider definition of experience, fully agree. And I don't have a problem at all with this application. I think that, as I think you were, when we were talking informally earlier, you said, what is this vanity that you have to be invited and you don't want to apply? I think it just, I mean, what's wrong with an application process? Right? What's wrong with application, right? I don't see any problem with applying to become a judge. I mean, if the process is going to be transparent, right? I think the reason why people don't want to apply today, and I think this is a surmise, I mean, I may be completely wrong, is because they don't know what the process is. Why should you make an application?
And when the process is.
You don't know who,
when the process is
when,
going to happen
how,
or not.
If. So nobody wants to put themselves up in that.
Put themselves out or give out their credentials and say, here I am willing to be considered.
In that position, right?
By whom?
To whom?
When?
So
Where?
I think when, everything is unknown, application, that's why most people hesitate. But I don't see a problem with application. See, I mean, look at it. I mean, the very essence of democracy is you put yourself out there. You give people who select you, elect you, should know who you are. And people should know, the wide society at large should know who you are. It can't be a surprise at the last moment.
To be very honest, my thought was totally very different. When I thought if I were to be asked, what would I suggest? After hearing both of you, I feel what you people are saying is making more sense than what I had in my mind. See, all said and done, one is I agree today we have so many new advocates that are coming. So we need to give them a different platform, a different career, a different, something to look forward to. Not this old vanity or some colonial thinking of having a collegium and secretly, trying to select somebody. I think that we have to really come out of it. Having said that, a student who has come out of law school today is going to be in the realm only 25 years from now, whoever it is.
Yeah.
We are all now 25 years, but we must say we are all kind of passed out of the 50. The ones who are a decade earlier, who are in their 40s, they still consider the judgeship to be more of a sacrament or a service, I feel, I don't know if I'm wrong, than a job for which I have to make an application. So this, I think, is a mindset. Having said that, we all were a part of, both of us were a part of, submitting something to be designated as an advocate, which was a wonderful process when I look at myself, what I went through. Changes that I feel could be, we've already made a system now, putting up on the website of all the advocates who are interested to be designated and things like that. The same stream, create a parallel one where whoever is interested will be put out, and then they will be scrutinized by putting their credentials out. Whoever wants to make an objection or say anything will, with their name and their information, will say these are, I feel, are the objections for that. So once you have the screening in this fashion, then you can select judges. Somehow, I personally feel involving anyone outside the judiciary. Again, see, this is my colonial thinking, which is there deeply sit in. The concept of collegium, which was there in my career as an advocate, I find somewhere it becomes impure. The minute you bring in either a secretariat, minute you bring in ministers, or I'm not saying for a moment that they are non-kosher or they don't have the capacity to appoint. But somewhere I feel it's going to...
So I have two thoughts there, right? One, see, the reason why I think an application process is not a problem is because it increases the pool of people you're considering. Okay?
Certainly.
If you also want to invite some people, go ahead, feel free. I don't have a problem, right? But this creating an application process or keeping an application process open means people you may not have considered, you may find good people, okay? As against saying, okay, I will only, consider these 10 people that I have seen. I think it increases the pool of people you are considering.
And I think eventually we will all get used to it.
See, also, now, I mean, just take a look at, any mid-sized or large high court, right? You have between 35 to 50 judges,
yes,
right? Between 30 to 50 judges. And the way the rosters are divided, you could spend 25 years without having seen, or rather having seen only about 20 advocates. Say if you're only dealing with, say, let's say tax matters.
See, that is right? Because I will tell you why. Yeah. Because I'll tell you why. The litigation that we have today
is becoming more and more specialized.
Specialized, and only a small pool of advocates are dealing with large litigation. I mean, large number of litigation, and the large number of advocates are really having.
We're going into other problems of the legal profession, yes, which I will skip for the moment.
This is all
correct. It's all connected. It's all connected. But what I'm saying is, see, it feels great, and I agree with you, the point that you made that, being a judge is not necessarily a professional choice, but it is,
more of an honor.
It's a commitment.
Yes, not honor, a service which comes with a dedicated service that I dedicate myself to give that service.
No, I agree with that. I don't necessarily agree with the honor part.
Okay.
I think this is where we have gone wrong. We're saying, it's an honor, I mean, you're doing you're doing your duty to society. I don't think this honor. See, the path between honor and power going to your head is very, very narrow. Yes. Okay, so I think we should
I'll add one more thing. Earlier, I think the salaries of the judges were so low. So the honor part, I think, made good for it. Right. But I think today the salaries of the judges are at par with any executive or anyone who can really run a proper family.
But the point that you make, that there's a certain status attached to being a judge because you're delivering justice, I agree that it is something more than just a simple profession or anything like that. There's an element of duty that comes in. There's an element of higher morality,
sacrifice,
that comes in. All that, I agree with all of that. So it feels great to say that, listen, I was invited to be a judge, and I don't take away from that. I think that I fully agree with it, and it's an honor to be asked by a group of people you look up to, to join the club or to join the ranks. Club may be a wrong word, but to join the ranks is a good thing.
Yes.
But the reason why I agree with Prashant that there should be an application process is because the world we live in has changed. The world of lawyers has changed. And the wider set of lawyers, people, for example, who don't have, parents who have been in the profession, who don't have relatives who have been in the profession,
yes,
that number is increasing. Now, for them to wait to be invited is not correct. Because, see, even invitation, I think we should not be blind to reality. Invitation also happens. Yes, in some cases, judges see lawyers arguing and say, this lawyer can make a good judge, yes. But other judges tell the Chief Justice and the two senior most, why don't you consider them? Now, why is that other judge, recommending A versus B? Some could be, purely, because he or she is a good lawyer. In addition to he or she being a good lawyer, it could be because, they're familiar, okay? So I think this ensures that familiarity does not become a problem.
Again, as a primary motive
that's correct.
To recommend.
I am not saying that you stop recommending. I am not saying that at all. I am saying you also open up the application process because that is the only way you're going to make this more transparent.
Well, on this issue, I feel that once you open
one
with
minute.
application,
this application being opened is not uncommon. You have said that even senior advocates are supposed to.
I agree with you. But there is a senior advocacy is for the benefit of the individual. You see, there's a lot of difference. Getting designated as a senior advocate is for the benefit of the individual and for the clients who feel like, let's say, why are we having a senior advocate? Like, let's say there is a company. The company doesn't know whom to decide. To take so they will take a designated senior advocate. So with that, their responsibility is over. So I don't know. I feel this is more to do with individual. But when you are serving as a judge, you are serving to the society. When I appear for a matter for a company and stand before and give my best to the court, I am not doing anything to the society. I am only doing to that client. So there is a lot of difference is what I feel. So therefore, once you put application in place, question of invitation is just goes out of the window. See, then the whatever the vanity that it is, not even vanity, the prestige that it is associated, the judgeship associated is going to go down.
See, Anu, I mean, I agree totally that I won't even say vanity. Maybe we can modify that. I think there's a purity to the process of being invited.
Correct.
Okay, but I think that purity has been long gone.
Yeah, it's long gone.
It's long gone.
It's become fully impure now.
Right. I also agree, and this is a point, a former judge who was part of the Collegium made. He said, listen, if I publish all the names that I considered and did not recommend, then it will negatively impact the people who were not recommended.
Correct.
And I buy that also, right? So but there are many ways to deal with that. For example, if 100 people apply, and then you are only considering 10 out of this 100, and there are only 5 posts, then you only put up those 10 names. You don't have to publish that all the 100.
But once the application happens, then
application can be there for inviting public scrutiny or comments or whatever, right?
You only put out those.
You put out those 10 names because the people who are selecting are not going to consider the rest of the 90. Then don't put them out. It's okay. It's all right. You would say, you may tell some of them you apply after 2 years, 3 years, whatever, or don't apply at all. That's a separate point. So you put up the 10 that you are seriously considering to recommend. And if there are only 5 posts, right, then there may be some allegations against 3 or whatever. That's a separate thing. But I don't think the purity of the process will be compromised. I feel that the purity of the process will get enhanced if you open the names to public scrutiny. Because you need to know, for example, there could be an individual who has behaved very badly with all the clients he's dealt with. But he's, very, very well behaved in court. Do you want such a person to be a judge? I mean, you probably don't. I don't know. I'm just throwing out this question.
No, I think I'll only add there that I would be more interested to know the emotional quotient of this person, because we would like a judge who is sitting there who will have a good emotional disposition, not who gives so much impulsive decisions, say something erratic to the court and disturbs. Most of the court's proceedings, we say, are all many times discussion is so many things other than the subject matter.
I agree, so but as I said, I don't think any methodology
will bring out this.
You can't guarantee that outcome, right? I don't think you can guarantee that outcome.
No, I see. For that, we will wind up in 5 minutes. Last word, yes, please.
Yeah, may I have some views of you on this committee which we have formed, the composition?
No, that's what I'm saying. So I have a totally different view. I agree, we need to enhance the age of the judge. I also agree that, earlier with the thought that a judge should have a good career, the appointments are happening at 45, so that you get a good 10 years or 12 years and then you still have some more years to be considered to go to Supreme Court. Now look at this. We are in Bangalore city, we are about 2.5 lakh advocates. And what are the posts we are looking at? 40. So it's very difficult to pick. And in 40 also, it's 1:3 or something.
2:1.
2:1, where you take from the promotion and the remaining is only from out. So which means you're having 20 odd judges over a period of for a period of time you have to select. So I feel a person who wants to become a judge should prepare at least 5 to 6 years prior itself. That means I have finished up to 55, I agree with that. So at 50, I choose. Now I made a home, I made a money that I want, I have become comfortable, my children are grown up. So now I would like to serve from the other side. I mean, this is my thought process. You may think it is very ancient. So I am comfortable. I don't want to go there and sit to be tempted to do something. 1. 2 is, no, but it is humanly impossible to have 15 years of seclusion from society. The tenure of the judges should be small. You take at 55 and at 65, from 55 this election will start. So I could be a judge even at 60 and then go on till 70, or 75, so that I have finished substantial
So
of my...
reduce from 15 to 10 is what you're trying to say.
Yeah.
Maybe.
Maybe. And then to Supreme Court, I feel that it should be predominantly seniority, and merit will certainly play a role if there's an exceptional candidate who has, shown great juristic skills in the judgments or anything, then you take such a person. But
if you ask me, I mean, they have wider powers in the Supreme Court, except in in one or two areas, and they have a larger impact on society. They can have a larger impact on society in the kinds of cases deal with. But somehow the career progression seems to be High Court judge and then Supreme Court judge, and everybody has got an eye on the Supreme Court. I think that also needs to go. I mean, I don't know how to, maybe this emoluments, maybe pension, all these other things.
The
I wanted Harish's view on other aspects which...
yes, please, you can ask.
What is the other object?
What is your view on the composition of the committee?
Of the selection team.
See, I didn't get a chance to sort of reflect on that. But, see, let me put it this way. Because the way the profession has developed and the skills required for appointment of judges, or skills required to be a judge, I buy the argument that outsiders may not be able to appreciate the relative merit between two candidates. I agree with that point. And judges or people who are familiar with the legal profession are best placed to make the judgment. Because this is the question you also posed earlier. If two candidates with the same experience, same background, who do you choose, right? That relative merit and weighing that relative merit, I think people familiar with the legal system are best placed. And somebody outside may not be, able to decide that. Therefore, you need to have someone from the judiciary or the legal system. And it could be, for example, the Attorney General or the Advocate General, a good, competent Attorney General who also does the same job. But you need someone from the legal system. So you can't exclude the judiciary and legal system from the selection process. I think what has gone wrong, and as long as we make a transparent system where the recommendations of each of the members of this authority is known, I think that's important. So you need a wider composition, yes. You need participation from the judiciary, yes. It cannot be the judiciary only, I agree. You can't exclude the judiciary also, I agree.
It has to be a good mix.
It's a good mix. But at the same time, let's be very clear.
So how can
I would say, Anu, if you have a body like this with all this calendar, your answer is got already.
It's already got.
Yeah, because they're preparing for it.
My colonial mind of breaking from the Collegium system is getting very difficult, hard, which I can understand why our judiciary also has not taken any steps in 10 years, because I think they keep feeling, let's make this better, but that better is not happening. And we really have a situation now where we need to bring in some system to make it better.
We are only commenting about the past. We are not looking at the future.
No, as Harish said, that we can never have a system which is going to be completely foolproof. But what we can have is keep changing the methods to try to bring out the best of what that method can give us.
We need to experiment with different methods.
And
just a comment on the example of the Pope that you gave. See, the one big difference is that the people who are, who are sitting in the Sistine Chapel to elect the Pope, it's only among them.
No,
that's
fine.
a big difference.
No,
right? They're not selecting from outside.
What I was trying to... That's exactly what they did in the end.
Correct.
No, what they're doing, that is exactly that. But what I was wanting to share is the sanctity of becoming a judge was equivalent to...
the purity of the process.
The purity of this process. And then the purity of the process means you're getting the best person out of that, because the process is very pure. So
you lock them up and say, don't leave until you decide who the next Pope is, right? But we are not, we are saying, okay, select from outside, that's the problem, right?
Right. So I think we'll have many more discussions on this, and you can never come up with a correct or a correct solution for it. We'll only have to experiment.